Gentlemen, how are you guys feeling after a bit of a sandwich and kopi? Good? Yeah? Hope you enjoyed the last session, and I think this session is going to be a lot more impactful, especially if you are in the business of creating IP or creating something, anything for that matter, and whether it's going to be relevant anymore. We're talking about the paradigm shift. Is protection still a competitive edge? Now, your moderator for today is Christine Ng of IPIC. She's the director. Let's give her a big round of applause. Our panel of speakers today are Vincent from KASS International, the Assistant Manager of Trademarks and Design Division. Big round of applause. And from IP Nexus, we have the Director of Partnership and Business Development, Arnoldo Concepcion. Let's give him a big round of applause. Ladies and gentlemen, let's discover if IP protection is still a competitive advantage. Over to you, Christine.
Thank you very much, Razif. Okay, so we'll probably have people still coming in. So we'll just start with, just to set the context a little bit. So I'll just start with welcoming you. Thank you for coming back so soon. I know you have just a short break just after the last session. Before we get our speakers to introduce themselves, can I just have a show of hands? Maybe just to get an indicator of the industry or the sector set you're coming from. Maybe academia. So I'll start academia, research institutions. Okay, we've got a fair bit. From the any government agencies? Okay. Do we have from the business sector, private sectors, businesses, SMEs? Okay, not many. What about big companies, MNCs, conglomerates? Nope. Okay. IP practitioners. So do we have maybe professional IP, lawyers, agents? So we've got, so we okay? Oh no, you okay? You don't count. You speaking. Okay. All right. So just to set the context, the topic. So it's pretty wide, so we are happy because we get to talk about a lot of things. We are not constrained, so we want to look at how the reason why I asked the composition of the room is so that we can sort of tailor make the messages or the discussion line more in line with who's sitting here rather than what we want to talk about. Okay, so paradigm shift. I think it starts with the perspective that the rapid changes of technology, not just the rapid rate at which it changes. So if you're from the software or from the IT industry, the step change is incredible. So we've got probably 3 major step change a year, probably. But if you are from the construction side, from the mining, for example, then it's pretty boring. You get probably 1 exciting change in every 10 years. Okay, so but I think just judging from the background of the participants sitting here, I think we are more interested in terms of the rapid changes of technology. Product life cycle is getting shorter. So we want to answer the questions, or rather it's a very thought-provoking question in terms of whether IP protection is still a competitive advantage. So in this case, we will tailor the messages that comes out from the panel of speakers in terms of looking at IP strategies. So in terms of different contexts, so IP strategies, protection of your IP assets, growing your business by employing different IP protection measures, different strategies on how to leverage on your IP rights and IP assets. Okay, so I'm going to just give some statistics in terms of in terms of wealth of companies. So based on some of the data that we have, enterprise firm value are increasingly being accounted for by intangibles. So we have numbers as high as 80% of firm value accounted for by intangible assets. So for the more developed countries, World Bank even classifies the wealth of nations according to intangible assets. So the more developed a country, then the proportion of wealth being accounted for by intangible assets, of which IP is part of, goes up higher. Okay, so it's very relevant for Malaysia since we are in the race of becoming a high-income nation. So I think that the key question would be for everyone here is to how do we sustain that? So once we reach that high-income status is one thing, is to sustain that. So it's to look at how we can consciously leverage on our IP assets. Okay. I'm going to start with Vincent, because Vincent, well, he's Malaysian, so we're going to start from the perspective of how IP protection probably has evolved over the last 10 years. We'll get him to talk a bit about the landscape in Malaysia. But before that, he's going to introduce himself, company that he's from, and what is his role in the company, to give a better context so that when you ask him questions, then you know where is he coming from. And then we'll move on to a more regional and global flavor perspective. We'll get Arnold to talk about some of the trends that he has observed over the course of his work. Of course, he will start off by talking about his company, where is he from, what are the things that he does to also give a better perspective and concept. So I'll start with Vincent.
Okay.
Yeah.
Thank you. Hello, thank you for having me, and hello everyone. I'm Vincent, and I am the Assistant Manager of the Trademark and Design Division in KASS International. We are an IP firm based in KL, but we do have offices in Indonesia and also in Singapore. And my job is pretty much to look after the department. We do trademarks, designs, copyright, and also GI, geographical indication. And that's pretty much it, I guess. We are a full-fledged law firm, not law firm, sorry, an IP firm. And we deal with anything that has got something to do with IP. And you're saying about how Malaysia stands, right, at the moment. I like to think of IP sort of like a house. And the progress of a nation in terms of IP is sort of like a house buyer or a house owner. If you've just started out working, you probably don't have the money to buy a house. So what you do, you probably rent a house. So you'll be staying in a house that's not yours, but you have the license to use it. And when, a few years time, a few years down the road where you've got a bit more money, if you're in Malaysia, you probably won't be able to afford a house that soon. But let's say 10 years down the road, you have a bit more money. So you're thinking of buying a house. So you have your own house that you own. And then after owning the house, you probably think of, oh, okay, how am I going to protect the house? Do I need insurance? Do I need like triple locks, quadruple locks? Do I need like a guard dog, something around the house? Put a fence with landmines around it. So, and then the third stage is where you already have a lot of money, hopefully by monetizing on your IP. And then you will think of buying a house or erecting a house as an investment. You may stay in them sometimes, but you're thinking of more so to how you are going to use it as an investment. So if you think of IP as a house and country as a house owner, it's pretty much the same. Malaysia probably 20, 30 years ago, before I was born, we don't really have a lot of our own IP. We have, when we think about franchise, we have McDonald's, we have KFCs, we have probably a bit later, then we have Kenny Rogers, and also A&Ws. So we are sort of like renting. We're using other people's IP. So we're bringing them in. And Malaysia, at the moment, we're sort of between stage 2 and stage 3, where we do have our own IP, a lot of our own IPs, in fact. I think next door just now we had Dato Nelson of the Nelson's Corn, and then what's the other one? The other fast food, Bobby Brown. Mary Brown, sorry, not Bobby Brown. That's also local. So now we are owners of IP, and then we are also going to think about how to monetize them, so as a franchise, we go local and then we go overseas. So we're sort of between stage 2 and stage 3, where most of the people are still, they do own IP, but I think in their mind most of the time they're just concerned about how to protect them and not allow other people to use them. Whereas I think stage 3 is something that we want to go into. That's why we have this IP evaluation thing, because we want to show you how valuable your IP is. So we want to be able to own IPs and also have, I think, IP right at the outset before you even start your business to actually monetize it on how you're going to incorporate that into your business strategy. So as like a house owner that's buying a house to invest, not so much to just stay in. So Malaysia is, like I said, is about stage 2 and stage 3, whereas I think a lot of the countries in the West, the US and Europe, I think Arno will probably be able to understand that. They already have at the outset, when they create an IP, on what they're going to do with it. You know, it's not just, okay, I have this now, so I have to protect it, but I have to protect it so I can actually use it, or to license it, or to sell it. And back to today's topic, is protection still important, or rather, is it still a cutting edge? I think both of us would say that we have vested interest in this topic, or we're definitely going to say yes, it is important. Because when you think of IP, intellectual property, you have to think of it as a property, as an asset. And with any asset that you have, I'm pretty sure you want to protect it. That's why when you left your house today, you locked the door, right? You parked your car, you locked the door, because you want it to be yours. You don't want to go back 3 hours later and your car's not there. And that's very important as well, because IP is an asset. You're bound to want to protect it. And what has that got to do with the value of an IP? It's actually very simple. Consider this. Let's say I have a brand new Ferrari. I've never driven it before. And out of kindness, because I'm normally kind, I would sell it to you severely under the market rate. So let's say I have a brand new Ferrari. I will sell it to you for 150,000 ringgit. But there's a catch. The catch is you have to leave the key to the Ferrari on the dashboard, and whenever somebody else comes along and say, hey, I want to drive that car, you can't stop that person. Will you still pay 150,000 for a Ferrari? Anyone? Probably not, right? Because when you pay 150,000, even 1,500, you want to have monopoly over what you do, and you also want to have control. Let's say you don't mind your wife driving it, which usually not the case, but then you can let your wife drive it. You give her a license to drive it. So with protection, it gives you that. Nobody's going to buy something that they cannot own, that they cannot control. So I think that's why protection is I think inherently important to the value of IP, and that's why it's still important. And although we are seeing that a lot of the times, especially in the technology sense, something will be obsolete once it's invented, or like 2 weeks down the road it'll be obsolete. So is registration still important? Because when you talk about protection, you have to think of it. It's not just registration. There are many ways of protecting your IP. So registration is just one of them. Maybe if something that is going to be obsolete, in 2 weeks' time, then you may not want to apply for, a patent, but you still may want to keep it as a trade secret, because you want to have it and you don't want anybody else to have it. So the means of protection may differ, but the need for protection is always going to be there.
Thank you, Vincent. I certainly have some questions, and I'm sure you too. But maybe what we can do is, before I open up questions to the floor, or maybe just to get some of my questions across to Vincent, I will let Arnold comment about some of the trends of IP strategy and protection that he has encountered. Yeah.
I was gonna show a slide, but I think I'm gonna skip that just briefly.
No, sorry.
No,
yeah.
I think
I think sorry, I forgot that it's critical probably for.
No, not really. Actually, I'll speak briefly on what we're doing,
so
but then
yes,
kind of
okay.
go into the topic, because we don't have that much time, and then
because we started a bit late, I don't mind opening the floor a bit more if you want to show your slides. If you want to run through them.
Okay, let's do that quickly then. Yeah. So I work for a company called IP Nexus. We are an IP marketplace. We're a startup We're based in Tokyo and in Hong Kong right now. And what we were, when the company was founded, to try to provide solutions and answers for several related issues. First of all, we'd like to help startups, new businesses. Normally when a startup gets organized, oftentimes they do not have, or most of the time, they do not have the funds to get access to legal advice, to business advice. And many times they don't know what they should be looking at. They're not even aware of what they do not know. For more established institutions, universities, governments, bigger companies, oftentimes they're looking for help in various areas. First of all, they may want to get legal advice in markets outside where they're based. But normally this is done through informal contacts. You talk to somebody who's your friend and has dealt with someone in Peru, for example. We wanted to provide a way to gain access to a repository of information on this. Also, more established companies and again, universities, government institutions may have intellectual property that they would like to do something with. And we're trying to provide a solution for them to connect with parties who are interested in accessing that intellectual property. So let me take you quickly through. Okay. So as I said, this is just kind of a summary of what I just said. We're trying to help a broad group of entities, startups, inventors, companies, universities, and put them in contact with solutions. With our user base, right now we have almost 2,500 lawyers and patent attorneys and other types of professionals and experts. And the way it works, we have various features. You can search for expertise. You can post questions and get answers for free from lawyers on our website. You can post jobs. You can soon, in a few weeks, we're going to go live with a startups listing, so you can showcase your enterprise and gain access to advice, gain access to a network, and possibly funding. And you can also market your IP. This is the page for our Ask an Expert feature. You can ask. Right now we have most of our membership is IP lawyers, but we're also expanding into other areas of other types of lawyers. The IP exchange, where you can list IP and market it. The services marketplace, where you can post jobs, and if you're looking for legal advice, or if you are a lawyer, you can come in here and help people. You can negotiate prices and provide services through our platform. And our expert directory, where you can find out, get help in different markets around the world. And see who's doing what. The startups listings will be going live probably later this month, and this will be also a way for startups to connect and get help. We have strategic partnerships with many institutions around the world. We are a partner of WIPO on 3 levels. We're the only entity worldwide that has this type of partnership with WIPO. We work very closely with Stanford Law School. Right now we are promoting an IP conference that they will be holding in August. And this is the last slide. This is what you see when you come to our webpage, our homepage, the first page that you will see. I think that's it. Let's go back to. So the question is the paradigm shift. Is this IP protection still a competitive advantage? And as Vincent was mentioning, this IP is an asset that hopefully, thinking about it from the perspective of a startup, you nurture it, you grow it, and someday, from the beginning it has value, but hopefully you keep growing that value until someday it becomes very, very important. You mentioned there was 80% of enterprise value right now?
Yes. So for some of the statistics or data collected, some firms up to 80%. So
Up to 80%.
it averages between.
It's almost almost the entire enterprise.
Yes,
is
for
IP.
some companies, especially if they are IP intensive, then it could be up to 80% of firm value that is accounted for by intangibles. Yeah.
And so, and then the question becomes: Is protection still a competitive advantage? Is it still providing you with an important strategic value for your enterprise? And I think our answer would be yes, definitely. And so I'll give you an example. Disney, the Walt Disney Company, in their main asset is their brand. In Japan, in the 1960s, there's a joint venture between a train company and a real estate developer, and they developed land in an area next to Tokyo where it was they reclaimed land from the sea. It was a fishing village. They bought out the rights for the fishermen. They refilled that area and they just reclaimed quite a lot of land. Decided to bring a world-class leisure and entertainment facility to Japan. At that time, Japan was underdeveloped, and they were in their process of becoming what they are today. So they went out. This was in the early 60s. After the first phase of the project, when they reclaimed the land, they went out and started looking at amusement parks all over the world. And they went to Europe, they went to South America, they went to the United States. Finally, they ended up approaching Disney to bring something to Japan. And at that time, Disney was, by this time, it was the early 70s, and Disney was already well underway to building Walt Disney World in Orlando. So they were not interested in investing in Japan. It was at that time, it was not the big company that it is today, and the capital was very limited. So they turned down this approach by the Japanese. A few years later, the Japanese came back and said, look, we really want to do something in Japan. Let's work together. And again, still at that point, Disney did not have the capital, because now they were investing in Epcot, the second park in Orlando. This was the mid-'70s by that time. But they said, okay, let us come to Japan and take a look at what you have and kind of listen to your proposal. So they went, they discussed. Eventually, they came up with a proposal, with a deal where Disney put up no money whatsoever. This is the only arrangement of this type for Disney worldwide. Everywhere else, Disney owns and operates and manages the parks. In Japan, they have no ownership stake. What they did was they licensed the Disney name. That's all, the IP. They took that IP and they licensed it. And the name of the Japanese company is called Oriental Land Company. They put up all the money. And every year, they built everything. They set up a liaison office in Japan to deal with the royalties and the management of the IP, all those issues between the headquarters in California and the company in Japan. And since then, every year, they pay a very large royalty to Disney. Disney spends no money. Disney gets reimbursed 100% for all their personnel in that liaison office. And right now, it's a very, very substantial part of the parks and recreation division of Disney. Maybe more than 20% of what they're making worldwide. So you can see how this concept of IP is so important. And they grew this brand, and now it's making a fifth of their profits for this division. So when you're thinking about it, I noticed that many of you, or most of you, are from government or from universities. And I imagine you're here because you're either dealing with startups or are trying to encourage startups to grow or advising startups. And I think a good way to look at this is in terms of education for startups. You have to think from the beginning, how are you going to manage your intellectual property? Because this is something that oftentimes people do not think about, how to control, how to manage, how to protect until there's a problem, and then that's the wrong time. It can become, you can lose control, you can, many times you have to spend a lot of money to protect. If you had taken some steps earlier, it would have been a lot easier and more cost effective. So in the context of startups, you should always think about, from the beginning, start thinking about these aspects, and take steps to take control of what you're doing. Most of the time, we recommend, when people come to us with these questions, the initial steps: register your business, register your trademark. If you have, depending on what you're doing, you may also want to think, and what your budget is, you may want to think about provisional registrations for your patents. Sometimes these things are, the registration for the patents may not be necessary, but if you're dealing with employees, if you're dealing with other parties that are gaining access to, or getting access to your ideas, keep control of these things. Use NDAs, use provisions in your employment contracts to maintain control of your ideas and what your employees are doing for you. And then continue to be involved, be informed about what you're doing. Do not lose sight of this very important asset.
Right, thank you. So as Vincent mentioned that, admitted that both of you have vested interest in terms of saying yes to the fact that IP has still relevant and still has a competitive advantage. I'm just going to push the limit further by asking, are there any circumstances, or are there any business models, or situations where having some thinking about or investing in IP protection would not be beneficial or would not help? Or maybe can you think of examples of companies who are thriving despite not having any IP protection as part of their focus?
Well, sometimes it depends on what industry and what your business is, but you should. It's normally not a good rule of thumb to go out and patent everything, because there's the issue of quantity of patents, but also the probably the more important issue, especially for a startup, is the quality of your patents. So you want to concentrate. There are limited resources normally for a startup, so you want to concentrate on, if you're going to be patenting, for example, patent only those things that are actually useful and good and will benefit you. Don't spend all your money in a scattershot approach.
Oh yeah, I was just telling you just now that if you're a store in Petaling Street selling counterfeit, yeah, you probably don't need any protection at all. So you don't need to register it, because you're probably just freeloading off other people.
You're happy for someone else to develop.
Yeah, exactly. Yeah. So I as a company, there is always going to be this, I think, minimum amount of work you're going to do to protect your IP. I mean, think of a kopitiam, let's say, in a coffee shop. You have your name, right? You have a name for the kopitiam. That's a trademark. You want to protect it somehow. You want to prevent other people from having the same name as you. So if as even the kopitiam would need some sort of protection in terms of their IP, that it's very natural that as a startup, as a company, or as a multinational conglomerate, you would need that protection. Again, it's the way that you go about it, because you have probably, if you're a bigger company, you have a portfolios of hundreds, even thousands of different IPs. So what are you going to protect first, or how are you going to protect it? I think for companies, it's always a balancing act. How much you want to invest into the IP and how much ROI you're going to get in return. So with that in mind, I think it will give you a good idea on whether you need or need not use certain manner of protecting a certain IP. Yeah.
Okay, so since we're on the subject of money, I think one of the things that I come across that is quite that resonates with SMEs and startups and entrepreneurs is that IP protection seems to sound very expensive, right? So we pay people like you lots of money to
we provide a free service.
So success
we
only,
connect.
right?
We're connecting people with free advice. So
you take our money whether we are successful or not. So So I mean, have you come across? Can you share some of the approaches or any strategies that companies, especially the smaller ones, the startups and entrepreneurs, can look at taking smart approach in terms of maybe scaling the way they want to protect their IP so that they don't end up paying everything for IP protection and not much left for operating the business.
Me first? Okay. Shake your money maker. I think that's what comes to mind. You have to always identify where you're getting your money from, your business. If it's a very tech-heavy business, then maybe your patent is more important. I mean, your technology is more important than your trademark. But if you're let's say a retail business, then maybe your trademark is quite important because that's how people see you. That's the first thing people see. So focus first on what is your moneymaker, basically. What brings in the business, you protect that first. And also, because most IP is actually are actually jurisdictional. So eventually, as your business grow, you want to think of going overseas, going into other countries. Then always focus on, first of all, your main market. And second of all, countries where your products can be produced. So basically, we're looking at China, India, and Indonesia, where they have the capacity, or even Vietnam, where they have the capacity to basically reverse engineer anything in 2 weeks or even 2 days. So you want to be able to stem the flow of infringement from countries where your products can be produced, and also be able to enforce your rights in the countries where your IPs are sold in, your products or your services are sold in. So I think that's a good way to start.
Yeah, I agree with this, with setting priorities, and you need to, and that's where the being aware of what you have and starting to think about this from an early stage really helps, because you need to know what's going to impact, what's going to have the biggest impact on your business. In terms of protection, you also have to be practical, because sometimes depending where you're going to be working, you may not be able to protect your IP the way you want. So you got to think about how, let's say you put something in the market in somewhere where it's easily copied. How are you gonna deal with that? You got to think about that from the beginning. If you're seeking funding, you want to have certain minimum requirements met. You want to be registered. You want to have a trademark registration, and then depending what your budget is, you want to think about what you would want to do after that. If you're already funded, or you're working, sometimes incubators, accelerators will help you pay for certain IP registrations. We'll guide you through that patent registration process. So try to get as much information as you can, and think about these issues well in advance.
Okay, all right. Okay, so we've been busy talking up here. Maybe it's time for me to open up to the floor for questions for the speakers. Anyone would like to ask questions? Yeah. So if you could kindly step up, introduce yourselves, and state your question, and if you have any preference on who would you would like to answer your question. Yes, hi, Dr. Zahira.
Hi, I'm Zahira. The question on NDA. This morning I have some conversation with my friends, and we consider on the NDAs about industry. Sometimes they don't like to sign NDAs with the university. I'm from the university. Just because by signing it is as if halting them from going to other people who might offer similar invention or whatnot. So what's your tips on the best thing, maybe clause for NDA, or any strategy that we might need to?
Yeah, that's actually a very common problem, especially not just universities, actually startups as well. Because when they go to a company and they want to pitch, their ideas to the company, they don't want to, first slip them an NDA. Say, why don't you sign this first before I tell you my idea? Because that's always going to be difficult, because you need the money. So, in a manner of speaking, you sort of have to curry their favor. It's basically
that most of the time they won't.
Yeah, exactly.
They won't sign it. They'll refuse to sign it.
So it's I think you will have to make that decision on whether you're going to take that risk or not. And I don't think there's much you can do. Maybe you can try to, when you do have a working relationship with them, when you have that something contractual or something in writing, try to introduce clauses into those documents that would benefit, I think, not just you, both parties.
Yeah, and it comes again to the priorities. Protect what you can protect, and then you need, like you're saying, you need to carry favorites. Sometimes you just need the funding. So protect your brand. The trademark registration is pretty straightforward, pretty easy. And then I think when you're talking about NDAs, you're talking about more technology and patents and things like that. You have to think about what you need from them, what you want to present, and so long as you have the rights to do what you want to be doing, and you've given yourself the right rights when you're developing this technology, I think those are the main steps that you can take at the beginning.
Yeah. Sorry, just something to add. Arnoldo is right, actually, because most of the time when you approach somebody for funding, you can actually, before you actually approach them, try to at least file a patent. So at least you have something to begin with. So like, let's put whatever I have on the table, and then that will be in your favor because you already have a patent filing or that's already pending or a registered patent.
So in some ways you're already protected.
That's
in many
right.
ways.
Yeah,
you
so
come in with an idea and try to negotiate, but you have something that even if they want to steal it, they can't because it's already there.
That's right.
Protected.
I've got a trick that I'd like to share. So even though I'm not a speaker, but I thought that would be useful for maybe Dr. Zahira to consider. So we do a fair bit of trying to, so what my company does is that we help companies to deliver innovative solutions, products, services, processes, but we can't say that we are innovators if we can't do the job ourselves. So we commercialize our own portfolio of solutions. So because we are a small company, we can't possibly patent or file for protection for all our conceptual solutions, even though we might like to, because then when it comes to maintenance or if we can't find downstream partners, so we tend to be very cheapskate. So we've got this cheap low-cost solutions. So just shelve it until we find someone who's willing to spend the money. So, but of course we do have to talk to we need to access the money. So what we do is that we tend to split it up into phases. So usually the first few conversation, we will not really look at, because we have no bargaining power. So I think that the moment NDA comes is when you know that you've got some kind of bargaining power in your hands. So what we tend to do is that we will disclose things which would not jeopardize our legal avenues to file later on. We would tend to pitch more on the benefits, on what would benefit whoever that we are talking to, so without disclosing the secret. Okay, so it's about just getting the interest, getting the bite, and then later on, if you know that they are serious, or you can come and say that, well, we have spoken to you twice already. Maybe before we go on, we'll love to tell you the substance of it and how are we going to do it. But at this stage, we need to sign something. So other questions? Thank you, Dr. Zahira. Anyone else to get the speakers to earn their lunch?
Oh, man.
Hi, my name is Akila. I'm from Nano, Malaysia. We are agency under Science Ministry, overlooking nanotechnology in Malaysia. So one of the things that we do is matchmaking industry and university. So we did a lot with universities, and I realized one thing, that university have so many patents that's just laying around there and not being exploited until probably that lasts 3-5 years. And like you were saying, like you shouldn't patent every single thing. But I think university researchers tend to do research and patent it straight away, but not knowing whether there's a market for it or not. And what's your take?
I think for the university, it's slightly different, because I'm thinking about the prioritization is a matter of resources, and normally the universities will have much vaster resources, so they will just patent as much as they can and just have a huge portfolio, and then for them, the issue becomes monetization. How do they turn these resources into cash?
Yeah, I think I agree, because for universities also, especially in Malaysia, I think they need to get funding from the government as well, so they need to show certain KPIs. So I think there's not really a problem with patenting if you have the funds for it, but I think universities should also consider monetizing it. So can we actually license this to other parties? Let's say if it's an important patent, an important technology, can this actually be used? And that, again, I think brings us back to this topic. Like, protection is only as good as if you are going to consider using it, because there's no point protecting something that nobody wants to copy and nobody wants to use. So finding the right industry player, finding people who would require these patents, rather than not filing patents at all. I think that for universities, that should be the case.
For the universities, the business model now, it's becoming. This is in the United States, for instance. It's kind of becoming more and more in business. So they're getting these tuition fees, and they get the tuition fees from the students, and then they use the students, the PhDs, to continue producing this research. And then they're patenting, and hopefully the end result would be a product that becomes successful and then continues that kind of virtuous circle. But normally it's like 5% of these inventions become an actual product, and then out of that, a smaller percentage becomes something successful. So normally they just have a bunch of patents that are just sitting there, and their issue then becomes how do we license it, how do we market this, how do we make this into money.
I've got something to add. I have a slide, which of course I don't have it now. It shows the, it's basically a chart that shows UCLA's patent portfolio. So you've got probably 98% of them making zero returns, and only about 2%. But that 2% brings most of the income, which keeps it going. So I think not the answer, but I think the trick is to change the mindset of how perhaps because these are all public funds. Okay, so these are R&D that is generated using public money. So I think it's to transform the mindset to look at it from a very strategic perspective, like how investors, when they invest in something, they look at a portfolio approach. So it's not so much of individual. If we can look at investing in universities and research institutions in terms of their mission is to create new knowledge, push the knowledge frontier. And their job is to patent and protect as much. And then look at playing the numbers game. So I'm going to use this portfolio approach to generate returns. As long as we've got a positive returns, that even though it's percentage-wise, even though it is a single digit, it doesn't matter. So if I can draw a similarity between one of our clients, so I think they wouldn't mind sharing, because Procter & Gamble, they're a very successful company. They practice what they call the 4 Fs. Fail fast, fail forward. Meaning fail cheaply, fail quickly, so that you get to the success faster. They are successful in spite of the product failure rate is about above 90%. So
is that rate kind of unusual, or is that kind of?
I think Procter & Gamble probably are the very few organizations who can fly with it. That no, we fail 90% of the time, but we are still very successful, because they understand that if they fail quick enough, they fail cheap enough, then these failures doesn't matter. Yeah. Any other questions? Yes.
Basically, there has been a point in time, I have a small startup where we dabble with research, and we're trying to do new things for creative industries. And in the creative world, I understand the relevance of maybe protecting your brand, because it's something you're going to build, and that might fly and be something that makes you money in a form of intellectual property. But for example, we created an app, and this app's built on a CMS. And my lawyers are telling me, you can't patent this. You know what I mean? What's there to... Because the thing is, it's built on a content management system, and it's just an idea. I'm just re-innovating a few things. What's stopping another person from taking my thing and saying, oh, okay, we'll just change it a little bit, and my patent, if there was a patent, becomes irrelevant. So there's no copyright. There's no grounds for me to even copyright or patent. But trademarking, is something you have to build with a brand. So that might discourage an entrepreneur or a startup entrepreneur to get into that field of actually wanting to use IP as something relevant. Can I get your views on this?
I think it's definitely a sad situation, because we face clients like that almost on a daily basis. They have this idea, they come in, and then especially if it's to do with software or apps, then because it's an area where IP is still sort of trying to catch up, because it's possible sometimes to protect it with patents, but most of the time you're relying on copyright, which doesn't really give you much. But what you want is actually to protect the workings of that software or that apps. And most of the time with apps, you find that it's going to be very difficult. But you can think of other ways of doing that, because do you use Line? WhatsApp, you have Line. Because it's not something that's very new. They're not doing something that's very new. It's just a messaging app, but they've actually managed to go around the IP issue in the sense that they register a lot of trademarks, and they have industrial designs for the characters, for the icons on the app, on how it was emoticon? No, not emoticons. The stickers, the emojis and stickers. So they are trying to, again, using branding, but not necessarily just trademark. But you are looking also a whole package of branding, using design, using copyright, using trademark. So if you can go around the patent and copyright issue, because most of the time that's going to be obsolete within a year. So you're going to have to develop again. But you can't really reinvent the wheel, but you can brand the wheel differently and sell it differently. So I think with startup, that's something that they have to bear in mind as well, because most of the time with startups that are into software and apps, they tend to be very tacky. They not tacky, but like very on the technological side. So they don't really see it from the business point of view. Yeah. So that's if you can't do that, perhaps you need to get help from people who can tell you, okay, you have a good technology. You may not be able to protect it, but you can brand it. You can still sell it, and that branding may become very important.
Yeah. So as Vincent, you're gonna have to the practicality of it. You're gonna have to be practical about this. The pace of change is very quick, so you're not. It's not practical to patent something probably in that space. But if you can execute well, if you can come up with ideas and continue, because there's not a big difference between Line and WhatsApp, but they're all doing interesting things. Line is pretty popular here as well. No, so WhatsApp. Yeah, but in Japan they're actually teaming up with Disney with games. So within the Line ecosystem, you can buy games. You can buy all those stickers. So these are things you have to be thinking all the time and innovating as quickly as you can. Execution is going to be more important than the protection that you can get, because the protection you may be wasting resources, wasting time protecting things that do not need to be protected.
So something to add to that. So in cases like that, we normally encourage not just ourselves. So we have our own basically services or products that we feel that has no recourse to form protection to give us the edge. So normally what we do is we look at try to create entry barriers to discourage other like-minded competitors. So in the form of looking at, for example, your business model, revenue model, business model, which will make it difficult for competitors to copy. That's one. The other strategy will be look at what we call the staying one contradiction ahead of the competitors. So if you look at Samsung, again, we love working with them because of the fact that they have an elegant strategy. Their motto is they don't need to be the best. They just need to stay ahead of the competitor. In this case, they just wanted to stay ahead of Sony, which they did a few years back, and they are still very successful at doing it. So it's about not being a best, but staying ahead of who are you trying to stay ahead of. So pick your fight, pick your battle. You can't prevent everybody from overtaking you, but you can choose your battle wisely and build your strategies, your business model, your revenue model around those. So create that entry barrier as best as you can. And staying one step ahead of your competitors. So in this case, you've got that current app, for example. You launch version 1, but you already have what is that version 2 that your customer might want. But so you keep it when the moment you see competitors starting to come in, then you launch that one so that you will always be ahead of the competition. So just to keep yourself that competitive edge. Any other questions? Nope. Yeah. So we've got, well, we're on time. So maybe, do you have any final things to say? Could be witty, or we can talk about something else. But so yeah, as we were saying, we can start talking about food just to get everybody's appetite going.
Yeah. I think basically I keep saying this. I sound like I'm like a sex ed teacher. Like protection is very important. Like it is very important before you go into anything. So yeah, it may not appear to you. I think when you're starting a business, to actually get all your acts together and then get all of those protected. But it shouldn't be an afterthought, because when you have a business, you're like what Christine said just now. Like if you're very successful, 80% of that can be an intangible property. So, and with intangible property, it's difficult because like if I own a watch, it stays on my arm. As long as it stays on my arm, it's mine. But with intangible property, you need sort of like a paper to tell you that you actually own that intangible property. So, therefore, protection for intangible property is actually even more important, and that should never be an afterthought. So that should always be concurrent with your business plan, or actually ahead of your business plan, I think.
Yeah, I think that sums it up. Just be practical. Think about these things early on, as soon as you can, and keep in mind that resources are limited, and you're going to have to be strategic about how you look at this and how you approach it.
So thank you very much, Vincent, Arnold. So over to you. Yeah.
A big round of applause to our panel speakers. All right, everyone. Lunch is already served, but our panel, I'm sure, will stick around. If you have any intimate questions that you need to ask, you're not going to be open about, the NDAs, you know what I mean? Now is the time, all right? Other than that, lunch is at the ballroom. We'll see you there.